Hello everyone, welcome to this discussion. So we'll be discussing some of the questions of GS Mains 2, the polity part of the 2025 mains exam. I hope the students who have appeared, they have done well. And if I look at the question paper, the polity questions, they were some very applied questions and questions which are generally not from the very you can say routine conventional areas which you are looking at. Some questions were looking for some depth also, okay, especially the topics like comparative constitution, topics like RPA, salient features of representation of people's act, where some depth was required to write the answers properly. Okay, so we're looking at the questions now. I will be taking 5 questions in this discussion. The remaining questions will be discussed by other faculties. So the first question in the paper was, discuss the corrupt practices for the purpose of the Representation of People Act 1951. Analyze whether the increase in the assets of the legislators and or their associates disproportionate to their known sources of income would constitute undue influence. So they're talking about disproportionate assets, okay, and they are asking you whether it is a corrupt practice. Now if you look at this question, I still remember that we have very clearly discussed this in our classes itself. When it comes to RPA, what are the different corrupt practices which have been mentioned in section 123 of the RPA? If any person who is a candidate or the authorized election agent of a candidate is found guilty of any of these corrupt practices in section 123 of the RPA, shall be disqualified for a period of up to 6 years under section 8A of the RPA. This is what the provision talks about. Okay, so the question is asking you regarding discuss the corrupt practices for the purpose of RPA. So first of all, it was a very straightforward question. You had to mention about the 7 or 8 corrupt practices which are mentioned in section 123 of the RPA. So section 8A talks about the disqualification as a ground, okay, disqualification for corrupt practices as a ground, and section 123 is what defines the corrupt practices, defines it. Okay, so all the grounds are mentioned over here. So briefly, if you look at the grounds for corrupt practices, the grounds are, the first one is what? Bribery. Okay, or rather the first ground is bribery, okay, of any voter or candidate. What does it mean? If somebody tries to prop a dummy candidate, somebody says that a candidate should withdraw his or her name, or a voter should vote in a particular manner or not vote, all these things could be covered in bribery if somebody is trying to gratify any candidate or voter directly or indirectly. So you can just mention in brief bribery of any candidate or voter. Then you could mention about corrupt undue influence, the second ground on which a specific question has been asked in the second part. Okay, so what is undue influence? There are some very important words which have been used there. Any kind of threat, okay, threat to any candidate, or especially undue influence is talking about voters being threatened where they are not able to exercise their electoral rights freely. So any kind of threat, social ostracization, okay, social boycott, spiritual or divine outcomes, okay, spiritual or divine intervention that you will face this negative religious consequence or negative spiritual consequence. Okay? So if you are appealing that you should not vote to this person because he is anti-religion, because he is against your religion, so these things could be covered in undue influence. If you are giving any kind of threat of any injury, or if you are forcing anybody to vote in a particular manner, otherwise they will be socially boycotted, then it is undue influence. Then the other grounds are what? The other grounds are seeking votes in the name of one's religion, language, race, caste, etc. Same way, seeking spreading enmity on these grounds. Okay, then what are the other grounds? Promoting practices like sati, practices like sati. Okay, then it talks about carrying voters to the polling booth for free. Okay, then spreading false information about a candidate in the election. What else? Use of government machinery. And one more ground is what? Exceeding. There is a limit for every candidate to spend money in the campaigning process. So exceeding the poll expenditure limit. Okay, so all these are grounds on which somebody can be declared guilty of corrupt practices. Now this question was particularly asking you to write about undue influence and whether disproportionate assets with a candidate can be called as undue influence. Now undue influence, as I mentioned very clearly, it means what? If somebody is threatening, or so threatening that if you vote in this manner you will be facing a consequence, you will be beaten up, or your family members will be beaten up. Social hostilization means you are talking of boycotting the person. Spiritual or divine intervention, if you do not vote your religion is in danger, these things are called as undue influence. Okay, so you could mention about Supreme Court judgment also on this. Bhajan Lal case, okay, Chaudhary Bhajan Lal case. (1985), where social ostracization threat was held as corrupt practice. Then Abhiram Singh case, 2017, appealing in the vote, to vote in the name of religion may not essentially be undue influence. Okay, so you can mention one or two cases of this. Then Yashwant Prabhakar Kunte case was there, 1996. So there are good number of case laws which are available on this. You could mention about that also. Now very clearly you have to mention that disproportionate asset itself is not undue influence in this case. Okay, some kind of threat or social boycott or divine intervention or religious, you can say, or spiritual intervention is mandatory to show when you have to find guilty somebody for corrupt, for this undue influence, right? So you will have to mention this and then you can conclude. So if you look at the format of the answer, what will be our approach? In the intro, because it is a short question, a very small intro, we can mention that the RPA has provided for corrupt practices to ensure a free and fair election in the country, which is a hallmark for democracy. Something of that sort you can give as introduction. Then you can in brief mention about the grounds. for corrupt practices, then mention about what is undue influence, in particular those 3 or 4 essential ingredients with 1 or 2 cases, and then you give the conclusion. In this particular case, okay, it is not undue influence. Okay, this is how you have to write this first question. So it required your understanding of what is the meaning of corrupt practice, and this is a repeated theme. In the past also there have been questions on this. Okay, now we are looking at the next question. Now the next question is, comment on the need of administrative tribunals as compared to the court system. Assess the impact of the recent tribunal reforms through rationalization of tribunals made in 2021. Now this topic again, it has been in news. There was news last year also. There is a case going on. I think I had covered this also in the class when I had discussed about tribunals, that Tribunal Reforms Act 2021 was passed by the Parliament in 2021, but it has been sub judice. The matter is pending in the Supreme Court. Why? Because a Tribunal Reform Act was brought as an ordinance in 2020 during the COVID period. The same ordinance has been again introduced as an act in 2021, but that ordinance had been declared invalid by Supreme Court because of certain conflict of, you can say, opinions between the Supreme Court and the government. It was Madras Bar Association case 2021, where Supreme Court had declared some of these provisions of Tribunal Reforms Act as invalid. Okay, so in this question you had to first of all mention about the need for administrative tribunals. Okay, so firstly you can introduce, in the intro you can mention that tribunals are specialized quasi-judicial bodies needed to dispose cases of specialized nature quickly. Okay, something of this sort you can give the introduction, and then you can talk of why administrative tribunals are needed. So why are they needed? You need to give the explanation. So what is administrative tribunal? First of all, mention about that in one line. So administrative tribunals, they are taking disputes between government and its employees. Okay? Now if these disputes are going to a court, what is the average time which is taken to resolve a court case in India? The civil matter, it might take 5 years. Okay, so suppose a government employee is having a dispute with respect to his transfer or posting, it might be pending for 5 years. So neither the employee is happy, neither the government is happy with that. No organization can work in an efficient manner if its employees continue to have long-term grievances with the government itself, with the employer itself. So administrative tribunals became a necessity, right? So you can mention about that aspect over here. What is the need? So first you mention about the nature, and then you talk about the need. So administrative tribunal nature of cases is dispute between government and its employees. In need, you mention about the problem with the courts. Okay, and then mention about benefits with tribunals. Okay, so one line introduction, then one line you talk about why, what are the kinds of disputes going there, then 1 or 2 lines you mention about the problem with court, then 1 or 2 lines mention about the benefit of tribunals, and then 1 or 2 lines mention about CAT or SAT. Okay, so CAT was created by CAT Act 1985, okay, having 17-18 benches. Then there are several state governments which also have administrative tribunals. You can mention about the constitutional provision that they are all created under Article 323A, where only Parliament can create a tribunal of administrative nature. So this is the first part of the answer. Okay, now assess the impact of the recent tribunal reforms through rationalization of tribunals made in 2021. So after you mention about this in brief, you have to mention about the problem with tribunal. What is the problem with tribunal? There has been problem of, creation of tribunals in large numbers arbitrarily. There have been problems in terms of non-uniformity in appointment of members to tribunals. Non-uniformity in conditions of service of tribunal members. So non-uniformity in terms of qualification of tribunal members. So Tribunal Reforms Act 2021, what did it do? It rationalized the number of tribunals. It closed down some 8 or 9 tribunals. I think it was 9 tribunals which were closed down. For example, the Appellate Tribunal over uh, Censor Board, CBFC, under the Cinematography Act. Similarly, Appellate Tribunal over Copyrights Act, Appellate Tribunal over Trademarks Act. Okay? So some 8 or 9 tribunals, 9 tribunals I think it was, through this act, 9 tribunals were removed because very few cases went there. It was seen to be a wastage of resources unnecessarily. So all those cases which went to these 9 appellate tribunals, they were now to be given to High Court. Okay? So the tribunal will decide the case originally, and then in appeal you can go to the High Court. This is what was done through this law. Plus this law also provides for uniformity in terms of appointment, then qualifications, appointment, qualifications, conditions of service, etc. अब क्वेश्चन आपसे क्या पूछ रहा है? What is the question asking? Assess the impact of the recent tribunal reforms. Now, in the impact, what you can mention? Impact you can mention that even today, tribunals are funded by government. Okay, the appointment does involve the judiciary in the appointment committee, but if you look at their conditions of service, they are not as protected as the judges in the courts. Their conditions can be altered by an order of the government, right? Their employees are government employees, and many times they are working through contractual employees. Okay, so these are some problems which you can mention, that despite this law being passed, some issues continue to be unaddressed as directed by Supreme Court in the, so there were 2 or 3 cases, you know, Roger Matthew case were there, Roger Matthews case 2019. Actually this was the case where Supreme Court had given certain guidelines. Some of these guidelines were executed by this law, Tribunal Reforms Act. So you could mention about this case where Supreme Court gave some of these guidelines, and you could also talk about the issues along with this law, that many of these issues continue to be unresolved. Okay, this is how you have to mention. So it has rationalized the number of tribunals, provided for uniformity in terms of qualification, in terms of appointment procedure, but the problem lies in the funding of tribunals, in the independence of its functioning, because most of the government departments do have a lot of influence in the functioning of these tribunals, where the cases from government departments are also only going to these tribunals. Okay, so this is how you have to frame this answer. Because it was a short question, I have given you all the important points. You need to incorporate some of these important things when you are writing this answer. Okay, but of course it appears to be a relatively, you can say, difficult question in that sense, because you have to mention about 2 very important aspects in a short question. Okay, now coming to the next question. So next I am taking a long question. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. In view of the above observation of the Supreme Court, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability in India. Now this question is very clearly in the context of some developments which have taken place. I think there was a very important development last year regarding Mr. Arvind Kejriwal and Mr. Senthil, minister and chief ministers in different states, who did not resign after going to jail. Okay, and recently the Parliament has also brought the constitutional amendment bill for that, 130th amendment bill, which is a ongoing matter. Okay, so constitutional morality is a very relevant subject on that issue. There has been a question on the same theme in the past also. I think it was asked in the context of Delhi LG versus the central government conflict, which was the LG versus CM in Delhi conflict. Okay, so firstly you have to answer about what is constitutional morality along with relevant case laws. Then second part of the question is asking you to apply this concept of constitutional morality in ensuring judicial independence and judicial accountability in India. Okay, so this is definitely in the context of the ongoing controversy surrounding Justice Yashwant Verma's case. Okay, so first part what you have to do is you need to mention about in the intro, mention about constitutional morality. Okay? In the introduction, you can talk about the constitutional morality. What is constitutional morality? It means if something is not clearly provided in the law, those values, those morals which should guide you to take a particular decision, when constitution is not clearly providing you something in writing. So it is more about the spirit of the law instead of the letters of the law. Okay, so you need to mention some of these things when you write the introduction, that the constitution, often it was said, remember Dr. Ambedkar and many members, Dr. Ajin Prasad in the assembly said that a constitution is good or bad. It cannot be, a constitution is not good or bad, but it becomes good or bad by the people who run it. Okay, so you could introduce on similar lines, and then you could say if people follow the morality provided in the constitution, if people follow the spirit of the constitution, then of course even if something is not clearly written, there would not be any problem in running that constitution. So on those lines you can start the answer. Then you can mention about what are important tenets of constitutional morality in our constitution. From where are we getting it? Okay, so you could mention that in our constitution, morality, that means values, guiding behavior of constitutional bodies and office bearers, as well as citizens alike. Okay? So what are the sources of constitutional morality in our constitution? We can look at the preamble. Talking about sources, preamble is an important source of constitutional morality. We have values like secularism, socialism, democracy, equality, liberty, fraternity, all mentioned there. Then you have the fundamental rights, you have the fundamental duties, you have the DPSPs, right? Then you have conventions. Okay, for example, parliamentary convention is there. If no party is getting a clear majority, who should be appointed as the prime minister or chief minister? So there are certain conventions also which are not written exactly, right? And then of course there are Supreme Court judgments on constitutional morality. So this is a repeated question. The second part of course is new, judicial accountability. It has become a very, very important matter of debate. So the question has been asked in that context. Okay, so you can mention about some important judgments firstly, which are talking of constitutional morality in general. What could be those judgments? You can talk about judgments like Navtej Singh Johar case 2018, where Supreme Court talked about constitutional morality to prevail over social morality. Okay, and more importantly, there are two cases which were very relevant here. One was Manoj Narula case 2014, where Supreme Court had talked about minister resigning even if it was not required by law, right? Remember, the only qualification mentioned in the constitution about a minister is somebody must be appointed, anybody who is appointed as a minister must become an MP or MLA within 6 months of appointment. That is the only qualification mentioned. So even if somebody is arrested, even if somebody is accused of a criminal offense, unless he is convicted and disqualified, legally he is not disqualified to become a minister or chief minister. But remember, if a minister is in jail, it becomes practically impossible for a minister to run the government, because to run the department, because you have to meet people, you have to take decisions, you have to take files. It becomes almost impossible to run the ministry while sitting in jail. Okay? And moreover, they can influence the investigation part sitting in the office of a minister, of a government department in that capacity. So that is why, though legally it was not necessary, but morally, constitutional morality requires such people to resign from office. This is what Supreme Court said in the Manoj Arora case. So you can mention about this case, and then particularly talk about judicial independence and accountability. So what could you mention here? So one was Manoj Arora case and another was this LG of Delhi case 2018. Here Supreme Court had said that constitutional bodies should work according to constitutional morality and respect the institutional boundaries which are provided in the constitution. One should not work in areas of the other institutions domain even if something very clearly in writing is not provided. Okay, so judicial independence and accountability, you can mention that an independent judiciary is a part of the basic structure of constitution. It is all it is of utmost importance for a democracy to work, right, to function according to rule of law and constitutionalism. However, a judiciary must also be accountable. So you could mention firstly about a very important document over here, the Code of Judicial Ethics or restatement of judicial values 1997. It is an important source of morality for judges. Okay, it's a code of ethics for judges that you should follow these things, you should follow these principles to ensure that your conduct is seen to be according to the expected constitutional morality. So they have talked about judges not involving with people who are coming with cases to the court, judges not promoting their family interests while they're taking cases. So there are many guidelines which are mentioned in these judicial values. You could mention about this document and then you could mention about Supreme Court judgment on this matter. You could talk about Justice Karnan case 2017. So Justice Karnan was convicted for contempt of court in 2017. So in that case Supreme Court had very clearly said that judicial independence does not mean compromise with judicial accountability. Both of them must go hand in hand to fulfill constitutional morality. Okay, so this is how you have to frame this question. Alright, I hope you have understood this. Now next question which I am discussing is, the Indian Constitution has conferred the amending powers. Indian Constitution has conferred the amending power on the ordinary legislative institutions with a few procedural hurdles. In view of this statement, examine the procedural and substantive limitations on the amending power of the Parliament to change the Constitution. Now this question is a classic question on basic structure doctrine. It keeps on coming in different ways, in different language, in different themes. Okay, so 2 years back it was asked in 2023 mains, where you had to write about the approach of judicial review, parliamentary sovereignty in India and UK. It was 50 years of basic structure doctrine. Now this year again this question has been asked in a different way. So the first line is because remember, constitutional amendments and threat to constitution has been a very important political debate going on in the last 1-2 years. Okay, so Indian Constitution has conferred the amending power on the ordinary legislative institutions with a few procedural hurdles. So I hope you are understanding the first part, ordinary legislative institutions. So it means we are talking of the Parliament. So introduction, you can talk of what can be the introduction. The topic is constitutional amendment. So your introduction should address the question very clearly. So in the introduction you can write about a constitution which is able to create a balance between amendability for future needs and safeguarding its core values is something which can deliver the needs of a progressing society, something of this nature. You can create an introduction on these lines. You have to highlight the core of this question. There needs to be amendments to constitution to make it an organic document, but the core, the ideals, the important principles must be protected or safeguarded to remain the same constitution. If those things are taken out, it is a different constitution, right? So in the introduction you can summarize this idea, and then you can first of all mention that Article 368 of the Constitution has provided the procedure to amend the Constitution. Okay? Since it has provided the procedure to amend the Constitution and it gives the power to the Parliament. So it means what? It has given the legislative body the power of a constituent body also. So Parliament is having two powers, ordinary legislations, and as a constituent body it can amend the constitution. But when it amends the constitution, there are some procedural hurdles. Okay? So what are the procedural hurdles? One is special majority is needed. Okay? And second is that ratification is needed of 50% states is needed in amending certain features of the constitution. You can give some examples, features which are mostly affecting the federal features of the constitution, like election of president, the list of subjects, the this representation of states to the parliament, article 368 itself, GST council. You can give some examples. So these are the procedural hurdles. Okay, दो तरह के hurdles की बात की गई है, substantive and procedural. So you can write down that the article is explicitly providing procedural hurdles. That is why we call our constitution as rigid constitution. But if you look at the second part, in view of this statement, examine the procedural and substantive limitations on the amending power of the parliament to change the constitution. Now if you come to the second part, so next you can write down that the article is explicitly providing for procedural hurdle, but substantive hurdles, that is what can be amended, what cannot be amended, was not clearly provided in the constitution in the beginning. And even today it is not explicitly mentioned in the constitution. Substantive hurdles have originated through the Supreme Court judgments given in the Keshav Bharati case 1973, called as the basic structure doctrine. So then you can in brief write about the basic structure doctrine. You can write down that originally the constitution did not have any such limitations, and Supreme Court initially held that parliament can amend everything in the constitution. An amendment to the constitution will not be called as as a law under article 13, through which judiciary can strike it down under judicial review. But in Golaknath case, Supreme Court said parliament cannot amend fundamental rights which are immutable. However, in the Keshav Bharati case 1973, Supreme Court said parliament cannot amend the basic structure of the constitution. Those features which belong to the basic structure, if they are taken out, it would be equivalent to creating a new constitution. So that is not allowed, and it declared some features as parts of basic structure. So you can mention some of the features over there: federalism, secularism, democracy, republic, free and fair election, judicial review, independence of judiciary, and most importantly supremacy of constitution and limited powers of parliament to amend the constitution. So these points you can mention, and then you can very clearly say that parliament amended article 368 to clearly provide that parliament had all powers to amend the constitution through the 42nd Amendment Act, which was declared to be invalid in the Minerva Mills case 1980, again stating that parliament's powers to amend the constitution are limited. This is how you have to write in brief about the second part of the question. So first mention about the introduction, calling for balance between rigidity and flexibility. Secondly, talk about what is the procedural hurdle, then talk about what is the substantive hurdle, okay, and then mention about the basic structure doctrine in brief, and then you can make the conclusion that this doctrine has ensured supremacy of constitution. However, it would have been better if the Supreme Court clearly defines what are the important features of the basic structure to remove any ambiguity and misuse of this power by the judiciary itself over the legislature. That's how you can conclude this question. Okay, so I hope you have understood this question. Now the last one we are discussing is discuss the evolution of the Collegium system in India, critically examine the advantages and disadvantages of the system of appointment of judges of the Supreme Court of India and that of the USA. Now this is something which is a very straight away a topic which I have discussed in details in the classrooms. I've even discussed this appointment of judges in USA, what is the consequence of that, in details in the class itself. Okay, so if you look at the first part of the question, you have to discuss the evolution of the Collegium system. So if you look at the evolution of the Collegium system, so first of all, introduction. In the intro, what will you write down? In the intro, you should write down that a fair and transparent mechanism of appointment of judges is a very important requirement to ensure judicial independence and accountability. Why? Because remember, if judicial you can say appointment, does not involve the executive and legislature in some way, does not involve the elected government of the day in some way, then somewhere the accountability of judiciary might be diluted. Remember, each institution must be accountable to the other institutions. Separation of powers cannot be absolute. Okay, so in the introduction you can talk of this, that a transparent system of appointing judges is a very, very important requirement to have an independent and this accountable judiciary. Okay. Now, next you can talk of the collegium system. So first you can mention of constitutional provision. In brief, you can just write down that Article 124, what talk about. So and it is very clearly asking of Supreme Court, so you don't need to write about the High Court judges at all. You can simply talk of Article 124. Originally, what did it provide for? So originally it provided that President appoints in consultation with CJI and other judges if required. Supreme Court and High Court as required by President. But then you can mention that this word consultation, it was interpreted in the first judge's case. Supreme Court said consultation is not binding. Okay, 1982. In the second judge's case, 1993. And in the third judge's case, 1998, Supreme Court held that the consultation shall be binding. And in the third judge's case, Supreme Court had said that consultation shall be given by a collegium of CJI and 4 senior most judges of Supreme Court. Okay, because you have other parts to answer also. Or you can mention that in the second judge's case it was CJI plus 2 senior most judges. In the third judge's case it was CJI plus 4 senior most judges. Right? After that you can mention the 99th Amendment Act brought 2014. It brought NJAC for appointment of judges. However, it was struck down by Supreme Court in the 4th judge's case. And the collegium system is continued to be in use. This will be your first part, around 100, 120, 30 words or maybe 150 words. Then you come to the second part, critically examine the advantages and disadvantages of the appointment of judges of the Supreme Court of India. So if you look at the advantages and disadvantages of the collegium system, you can write down merits and demerits of Indian system. Okay, so in merits you can write down independence of judiciary. Okay, independence, and then you can talk of separation of powers, and then you can talk of another important merit is what? That judges are deciding the merits of a judge for appointment. What are the demerits? In our case, delays in appointment, and the most important demerit is lack of transparency. And another important demerit could be that the judges are having the main power to appoint the judges themselves, so it is taking away the power from the executive to the judiciary. So it dilutes somewhere the accountability of judges. It disturbs the balance between independence and accountability. Okay, that could be another point. This was the argument given by Dr. Ambedkar. Okay, to reject the consultation of CJI to be binding upon the president. And then you can talk of merits and demerits of American system. So in USA, president appoints and Senate approves. Okay, so what is the merit? The merit is that the system is transparent. It is participative. The other wings of the state are involved, so it makes the judges accountable also. But the demerit is, it is politicized. It results into influence of the executive in the appointment of judiciary. Very often judges are called as Republican or Democrat judges in USA. So this is how you have to mention, and then you can mention that in the Indian constitutional mechanism, where the consultation of judges is also involved in the appointment of judges, it was done to improve upon what was already existing in USA, where judges are not involved at all in the appointment. But by making this consultation binding upon the president, somewhere the delicate balance between accountability and independence appears to have been disturbed. So maybe you could take this line of thought, or you could just mention that the collegium system should be more transparent to ensure that there is a balance between accountability and independence. Okay? So on these lines you have to prepare your answer. I hope you have understood what is required in these answers. Okay? So overall I could say that the questions are much more applied. They are, to my understanding, on the difficult side if you have to frame the accurate answer in the word limits which is required. Okay? All the best for your optional papers. Thank you everyone.